We have over 100 people connected. Many of these, or most of these, are clients of Creative Zones. Many of them have questions given the situation. We all know that we're going through a tough time, and many are having to adapt their structure. They're having to look into their human resources and how they can adapt to go through this transition or this period. Now, the Ministry of Human Resources and Immunization published on the 30th of March a new resolution, Resolution 279, that made changes to the law in response to this global COVID-19 outbreak. If you could give an introduction of what are the main pillars behind this resolution and who does this apply to? Because in this case, we have clients and we have people that have companies established in free zones, in mainlands. So who does this resolution apply to? And what are the main pillars behind this resolution?
Yeah, perfect. Thank you, Lorenzo. And thank you for starting with that question, because I think it's something that all of the people attending today's session are interested to hear about. It's really been the key development from an employment law perspective in the UAE. So I think I'll begin by talking about the objective of the legislation and the pillars behind it, and then we can talk about who it applies to. So ultimately, the objective of the legislation is twofold, really. One is that it's to support the private sector, to support companies, to support SMEs, to give them guidance around the types of measures that they can implement to their workforce to save some costs, and also how they should go about implementing those measures. But it also does give a little bit of protection to employees as well, and a little bit of support around things like the entitlement to receive certain benefits should an employer go through a termination process during this period of time. So in terms of what is the practical effect of the legislation, what are the pillars that the legislation has introduced? There are two key pillars to talk about today. So one is around the measures that it describes that companies can take if they're in these difficult economic times and they're suffering because of it. And the second one is around redundancies and being entitled to terminate employment if it comes to that situation. So talking about the measures to begin with, what sort of measures does the Article 279 introduce? There are 5 different measures that they talk about within the legislation. It begins with the entitlement to require employees to work from home, which is pretty straightforward. So, you know, if you've got the technology, obviously now we're in a more serious lockdown than we were back on the 30th of March, but all companies are entitled to require their employees to work from home.
And that was the first measure. This is what we all went into now. We're all working remotely, and that has been applied all throughout the UAE, right?
Yeah. So it's applied across the majority of the UAE, not the whole UAE, because there were some sectors that were exempt from that requirement to work from home. There's obvious ones that we know about: pharmaceutical companies, pharmaceutical shops, supermarkets, obviously not requiring their staff to work from home, but also other key sectors such as the construction sector were exempt from being subject to the lockdown as well. So construction workers were permitted to go and continue working within their work site. So if you were within one of the exempt sectors, then yeah, working from home didn't automatically apply. But actually, as you say, Lorenzo, for 90% of the private sector, it did apply, and people were encouraged to work from home. Beyond that, the next measure was paid annual leave, and the entitlement for companies to place employees onto paid annual leave. That's actually something that isn't new. And that is set out in the labour law. It's Article 76 of the UAE labour law, which gives companies the right to place employees onto mandatory periods of paid leave, depending on the requirements of the business. So even before COVID-19 existed, companies that I know would do that. They would do it perhaps during periods like Ramadan or during the summer, where there was an inevitable slowdown in their business. They would ask their employees to take 2 weeks annual leave, perfectly legal. You don't actually require employee consent to do that. The next 3 measures that I wanted to mention about do require employee consent, and they're 3 that are grouped together quite nicely. So it's a temporary reduction of pay, a permanent reduction of pay, and a period of unpaid leave. And for all of those three measures, you do require employee consent to implement those measures. But I think what the legislation does, Ministerial Resolution 279, is that it talks about that measure. That was never really described in any legislation before. So it talks about it, makes it more common, and certainly from what we've seen in the market, it's made it easier for companies to engage with employees and to agree with employees that this will take place, this will be implemented, and actually this is in the best interests of the business, it's in the best interests of the employees, because what those measures are good at is protecting jobs, because it means that companies can save some cost, but they do continue to provide your visa, do continue to employ you until the market comes back. They can get you back into the workforce, get you back up to your original salary. So that's one pillar, Lorenzo. That's about the measures that companies can take to save some costs. The other pillar is about redundancy procedures. And Article 3 of Ministerial Resolution 279 is, in some ways, it's a groundbreaking article, because for the first time in the UAE, we have a law that talks about redundancy. So this is two-pronged, actually, this article, because it's positive for companies insofar as it recognises that companies may need to dismiss people by reason of redundancy because of the measures that are in place, because of the economic situation. And I think if companies do dismiss by reason of redundancy during this period, in 6 months, in 12 months, if claims are brought against those companies for arbitrary dismissal and lawful dismissal, I think what we'll find is that the courts will be much more company employer friendly and much more reluctant to find in favour of the employee. So that's a positive from an employer's perspective. The downside from the employer and the positive from the employee's perspective is this obligation that if you dismiss during this period, because of the measures that are in place, you have an obligation to continue providing benefits. And it's described as all benefits, including accommodation, other than salary. So the question is, well, what does that mean in practice? What do we have to provide? What can we stop providing? And we'll probably get into this in more detail as we go through the session. But a very high level review is that the legal interpretation of that legislation is that basic salary stops at the termination date, but everything else like visa, medical insurance, housing allowance, housing if you provide accommodation, should continue until one of two things happens. Either the employee gets another job in the UAE, or the employee is repatriated to their home country.
Right. Well, this is where now a whole array of scenarios start opening up, and we've been receiving lots of questions in regards to these little different scenarios that one can encounter. So, for example, one that was coming out quite regularly was, what if there is no consent from the employee at the beginning of wanting to put someone on an unpaid leave? So the issue of not finding consent, how do we deal with that? Yeah,
really good question, Lorenzo, and that's something we've been talking to clients about over the past few weeks. And we did have one client who wanted to put a group of staff, their sales team, on a period of unpaid leave during COVID-19, during this period of time. And it was about 20 employees that they wanted to put on unpaid leave. And we went through a process of explaining the financial position of the company, explaining that we were putting people on unpaid leave, but you require them to agree to it. So you enclose a letter that says, this is the arrangement, you'll be on unpaid leave from the 1st of April to the 31st of May, and you agree to this. So then the employee signs it and returns it. And of those 20 employees, 18 of them did sign up to it, but we had 2 that didn't. And that's exactly the situation that we're talking about, Lorenzo. What does a company do in that situation? And we had 3 options, basically. Option 1 was we just push through the period of unpaid leave, just do it unilaterally. And so we write to them and say, dear Mr. Smith, We confirm that you are being placed on a period of unpaid leave from the 1st of April. You're not required to come into the office. You won't be paid for April and May. That's one option. Option two, of course, is make an exception. 18 employees have agreed, say, okay, well, these 2 employees can continue working, can continue receiving pay. But obviously that's not an attractive option for many clients because it's setting a dangerous precedent for the workforce. And then the third option is we escalate the process with those 2 individuals and we say, okay, we understand you don't want the period of unpaid leave. However, your role doesn't exist in the organization anymore. You don't exist. We don't have a full-time, fully paid sales position in this organization, which means that the only other alternative is that we terminate your employment by reason of redundancy. And so that was what happened. The client invited them to the dismissal meeting. And then at the dismissal meeting, if you follow the process through, is you terminate and then you say, but here's another job that's available to you if you want it. And it's a sales position. It starts with a period of unpaid leave for the next 2 months, and then you'll be paid from the 1st of June. Do you want to accept that? That's following the process through to the finish. What happened in the position with our client was the employees turned around and said, okay, well, I now know that 18 other people accepted this period of unpaid leave. I don't want to be the exception. I also don't want to lose my role with the company, so I'll accept the period of unpaid leave. So those are the 3 options really that you can go through with. So 1, unilateral period of unpaid leave, no further conversation. 2, you make an exception, or 3, you go through a dismissal process.
Right. Now, in the case of the temporary and permanent salary reductions, how do we go about making changes to the contract? Do these need to be reflected at the ministry? And how do we go about implementing those?
Yeah, it's a really important question, Lorenzo, and it's important for 2 reasons. One is the employment law risk in terms of, you don't want to get it wrong and then an employee brings a claim against you. And 2, for those clients that are in the onshore mainland area, the wage protection system is obviously going to be a key issue here. So in terms of the process that we recommend where we're agreeing reduced salary, we recommend that you have a short consultation. You agree with an internal document again, what the new salary arrangements will be. So that can be a letter or it can be an amendment to the terms of the employment relationship. Then once that's agreed, there's an addendum that the Ministry of Human Resources and Emiratization have produced that I can share with you after the session, Lorenzo, for you to share with any clients that want to see it, that companies are being requested to complete. This is a ministerial document. It's only a couple of pages long. And in order to complete the process for onshore companies, they do need to get that addendum completed. At the moment, what we understand from discussions with our PRO agencies, public relationship officers, is that the authorities are not open to receive the hard copies of these documents. So it's not possible to submit it anywhere. And equally, the online system is not receiving those addendums. So it's just not possible to submit it. But what the ministry has said is that companies should have these signed at the time that the reduction is being made, should keep them on file because they may be required to show these documents to the authorities if there's an inspection or if a dispute is brought in the future. So what we're saying to clients is go through the process I've just described, do get the ministry document signed by the employee if you're an onshore company. We don't think it's possible to register that at the moment, so just keep hold of it. And when the authorities open again, should be able to submit it if you wish to.
Right. Okay. Well, that covers a little bit these 2 aspects of putting people on paid and unpaid leaves. How do we go about temporary and permanent salary reductions? Now, the other element that you had introduced was the issue of redundancies. So guide us a little bit more. What are the steps? What are the provisions in the law that talks about redundancies? I understand that the ministry has introduced a virtual labor market where employees are meant to be placed on so that they can go into this pool of potential jobs. What are the requirements and how is the process for putting people on redundancies?
Yeah, thank you, Lorenzo. And, you know, as I said, before this article, Ministerial Resolution 279 was published, redundancy was always this very grey area because it's not defined in the labour law. There's an article under the UAE labour law, Article 117 of the labour law, which talks about dismissals for a valid reason. And that there was always a possibility of persuading a court that a redundancy was a valid reason to dismiss. In terms of the obligations when you're dismissing somebody for 117 valid reason, which is now potentially a redundancy, the legal obligation is to provide them with notice pay, you know, end of service gratuity, and all contractual benefits up to the termination date, including things like accrued and untaken annual leave. In terms of the process to follow as you lead up to a redundancy termination, that's not set out anywhere in the labour law. What we recommend to clients is that they pull together some evidence as to why this position is redundant. It's probably going to be a little bit easier to pull that evidence together at the moment. So whether it's lost contracts, whether it's clients that are sort of going away, pulling out of the business with you, perhaps it's your profit and loss accounts where you can see a clear kind of dip in productivity. Things like that's really helpful. Once you've got that evidence in place, what we recommend is an invitation letter is sent to the employees to invite them to the meeting to discuss the business and discuss their position within the business. You then have the meeting, explain the situation to the employees, explain they're being made redundant. You confirm that with the termination letter. And when you give the termination letter, that's when the notice period starts to run. So from that date, they'll have a 1, 2, 3 month notice period where they continue to be an employee, but they're serving notice. What we recommend to clients at the moment is that from the point that they issue the notice of termination, that's when you should be trying to register the employee onto the virtual labour market. The employee's details should then be on the virtual labour market. We haven't yet seen much development in terms of employees being picked up on that labour market. I suppose that might happen as we come towards the end of this economic sort of slowdown, as companies need to start rehiring. They'll probably start tapping into the virtual labour market probably in the next month or so, and we'll see employees being pulled out of the labour market and into positions. But that's the way it should. That's the way it's intended to work in practice. I understand that the virtual labour market is open. It is possible to register people there, but it just might take a bit of time for companies to kind of understand the way the website works. Beyond that, the termination date will then happen, you know, in 1, 2, 3 months' time, where the employment has ended. At the moment, if you cannot then repatriate the person to the home country, that's when those other obligations kick in around things like allowances, accommodation, medical insurance, until you can repatriate the employees. But beyond that, that's the legal obligation at the moment. That's everything companies need to be aware of.
Right. Well, to all the attendees, keep on sending your questions. We have quite a few good ones coming in. I have actually a very good question here from one of the attendees that relates to one of the previous topics, but he's saying, if we reduce, oh sorry, it moved my little chat, 1 second. If we reduce salaries as an NLC company and we can't submit the documents, I'm assuming we won't get a company block then?
Yeah, I mean, that's a really, really important point and a really difficult question to give a concrete answer on at the moment, because, so this is talking about WPS, Wage Protection System. As an LLC onshore entity, you'll be registered with the Wage Protection System. And I think what the person asking the question has quite rightly raised the point that historically, the moment that you don't pay the payroll as the authorities expect to receive it on a month-by-month basis, a block comes into the system. So you can't get new visas, you can't cancel visas. Now, we haven't seen anything from the authorities to tell us whether those blocks are being implemented or whether they're not being implemented. From my discussions with clients, I don't know of a client that has been subject to a block in the past month. That's colloquial. That's in practice, I've not seen it happening. What has always been said about the WPS in practice is that provided approximately 80 to 85% of the payroll is satisfied for LLCs, then WPS doesn't block. So that, again, that's not written down anywhere, but that's just what seems to happen in practice, that the authorities have always used their discretion to say, okay, 80 to 85% of salaries are being paid, so we're not going to issue a block for those types of companies. Whether that threshold will be brought down even further, so 60% of the payroll is satisfied, then that's acceptable. We don't know. Nothing's been said about that. But I do expect the authorities to be more lenient than they would be in normal circumstances around payroll. If you've got a good PRO who knows the authorities quite well, then I would definitely be advising you to ask your PRO to liaise with the WPS, with the ministry, to just let them know if you're intending to reduce salaries.
Right. And this is a bit of the work that we are doing with our clients. So all to our clients out there, we encourage you to keep a direct line with your client relationship manager, who can answer you all these questions, that can take a look, personal look in your case and how this WPS system is working at the moment. There's a lot of good questions coming in. There's one interesting here. It says, if the employee is already cancelled, are employers still liable to provide health insurance?
So is that the question, if the visa is cancelled?
I'm guessing if he has already maybe terminated him or put on redundancy, and he's still liable to pay allowances like transport, accommodation, are we still liable to pay for insurance?
Yeah, we would be, until the person gets another job or the person is repatriated out of the country. Then medical insurance would continue to be paid. The reason I was asking about the visa is because there is a technical point here that some medical insurance policies are tied to visa sponsorship. So for some clients, it's not possible based on the current package to provide medical insurance if the visa has been cancelled. What I would say, purely from a legal perspective, is that before you cancel the visas, you need to check what the position is with the medical insurance policy, because the risk here for clients is that they terminate employment, they cancel the visas, maybe the employee wants to cancel the visa, the employee doesn't have another job, doesn't have medical insurance, contracts COVID-19, for example, or has another serious illness, has huge medical bills, doesn't have insurance, can't pay for it, under the health insurance law, and now with this Ministerial Resolution 279, that is going to fall on the employer, that cost, from a purely legal perspective, that medical cost. So for sure, the safest approach for clients is to continue to provide medical insurance post-termination until they get another job or repatriate.
Right. We have another good question here, and it relates to the beginning of this conversation. It's saying, are these rules applicable to free zones as well? Specifically, Creative City, in the case of us having a lot of clients that are Creative City clients that we have engaged with and we have advised for.
Yeah, that is a really, really important question, Lorenzo. What we can do in order to deal with it is we can take out 2 free zones immediately. So the DIFC and the ADGM free zones, it's definitely not applicable within, because those are independent free zones with their independent employment laws. So the legislation is not applicable there. In relation to all of the other free zones, a lot will depend on the constitution of the particular free zone. Now, the starting position is that this Ministerial Resolution 279 states in Article 1 that it's applicable to all companies that are registered with the ministry. That's the starting point. In addition to that, this addendum that was produced that is part of the ministerial resolution related to it can only be submitted to the ministry by onshore companies. So those 2 factors indicate that this law is only applicable to the mainland onshore companies, not applicable to any free zone companies. But there's a few points that I want to make about that, because we have a lot of clients that are actually free zones in themselves, and some of them are saying we expect our companies to comply with the spirit of this ministerial resolution, because it has a similar status to the UAE labour law, and the UAE labour law is applicable in the free zones, so the ministerial resolution should be applicable as well. So that's one point for clients to be aware of. The other point is that, of course, if you don't pay the benefits and you get into an employment dispute and a person or a group of people bring a claim against you, and 6 or 12 months down the line, you're before the Dubai courts, the onshore Dubai courts or the onshore Abu Dhabi courts, they will have regard to Article 279, and it's likely that they will have wanted that to have been honoured by free zone companies. They often don't get into the detail around, are you free zone, are you onshore? The fact is the case is within their jurisdiction, they look at the law, they apply it. So I think the answer to the question, as I say, it's not straightforward. It's probably, if you want to be very safe, then I would apply ministerial resolution. If you want to be a little bit tougher, take a bit more of a risk, you don't apply it. But I would certainly be advising you to check with your free zone authority before you take that second route forward.
And again, I go back to this issue for all our clients. I request you to get in touch with us, with your client relationship manager, who can tell you within the different jurisdictions and the different authorities what is the law that applies, and we can help you through some of these questions. There was an interesting question here too. Is there a minimum threshold in salary reduction by which an employer can execute for an employee?
Yeah, good question. There's no minimum. The only percentage that's discussed anywhere is 10%, and that's under Article 60 of the UAE labour law. It talks about how a company can make a deduction to salary up to 10%. That has been overridden by Ministerial Resolution 279, which doesn't cap the level of reduction. So there's no minimum, so it can be as small a reduction as you like, and there's no maximum either. It can be as significant a reduction as you like. The key point is that in any situation, it needs to have the consent of the employees.
Right. Well, we actually had a good question from a director of HR from one of the companies that we assist. And she was saying, if there is a temporary pay reduction and then there is a termination, should the employer calculate gratuity on the reduced pay, or should it be on the original pay just prior to the temporary reduction?
Yeah, that's an excellent question, and something that we're discussing with our clients. So what we recommend, and what tends to happen in the market, is that when clients are reducing salary, at the point that we reduce salary, we set out the calculation of gratuity up to that point based on the current value of salary. So let's say we're changing salary on the 30th of April, the 1st of May. What we would do is say, up to the 30th of April, you've had 2 years service. Those 2 years service will be calculated at your current rate of salary, whatever that is. And the total of that amounts to X. Now, for any period of service where you're on the new salary, the formula will be applicable against the lower salary. So if the person then works for 2 months, let's say May and June, and they leave at the end of June, then that 2-month period should be calculated at the lower rate of salary. That's what we recommend clients do in practice. That is going to be quite often a key issue for clients, for employees, when they're deciding whether to sign up to agree for a reduced salary. However, notwithstanding that market position, which we very much recommend, the strict legal position is that gratuity is calculated based on your final basic salary. So if we don't talk about gratuity when we're reducing salary, if the person then leaves at the end of June on the lower salary, technically, a company could calculate it all based on the salary as at June, the lower salary. And it works the opposite way with pay rises. Of course, we all know that if somebody gets a pay rise in normal circumstances on the 30th of April, the 1st of January, and leaves 2 months later, their whole period of service is calculated based on the salary they had when they were leaving. So it works both ways.
Okay. All right. We're getting a few other visa-related questions from somebody called Manan. Manan, visa-related questions, we can help you directly ourselves. But it's a very good question. It says, employees who are outside the country and are supposed to be back within 6 months to keep their visas valid, if they are unable to enter due to flight closure, will their visas remain valid? So we will tackle these things, Manana. We will take note of this. We will have our client relations manager and our head of operations. We can give you all the feedback in relations to visas. But as of now, to what is out there, visas are being extended until the end of the year by the UAE government. But we will get into details on this directly. with you, with our team, Manan. A few other questions keep on coming up. Before I forget, and there's one that goes away from the topic, but I'm sure we're going to go back. What about hiring? What does the law do at this stage when it comes to hiring new people? Are there new systems in place? Are new conditions that we need to have in place for new hires?
I mean, the only thing that we're seeing on hiring is that, yep, for people outside of the country, obviously it's impossible to travel to the UAE. So actually, at Pinsent Masons, we have recruited a new employment lawyer who was traveling over from the UK to Dubai. It's not possible for that person to come to Dubai when they're due to start, which is the end of this month. So that person is going to work for us from the UK. That's what we're doing with that individual. So just having them work remotely. So external recruits from outside of the country is just not possible at the moment. Internal recruits, it's changing. It's changing regularly as to whether it's possible to cancel visas and obtain new visas. I did hear, because again at Pinsent Masons we were hiring somebody from another law firm as well in the process of doing that, that it was possible for that person to get a visa within the UAE, but it just depends on capacity within the authorities. You know, if you're in a free zone or you're in the onshore jurisdiction, it depends whether there's going to be the officers around to do the medical screening, to submit the local contract to stamp the visa, and that's what's creating a block in the system at the moment. It may be possible, I think, based on things like Resolution 279, it should be possible for a person to remain on their old company's visa, but get permission to work for a new company. And that's probably going to be the easiest way of dealing with it and the safest way of dealing with it for the individual right now, that they just stay on the old visa, but all of their employment transfers over to the new company. I think that's probably the best way to deal with it at the moment.
Right. There's another good question that is coming to me through WhatsApp, through one of our clients, saying, going back to payment of benefits when it comes to termination due to redundancy, is it an obligation to pay 3 months pay on top of the notice period? No, that's not a strict obligation. So I know where that's coming from. And actually we need to talk about that. There's two different types of employment contracts that people can sign in the UAE. There's the unlimited term contract that can be terminated with notice, and there's the fixed term contract that's for a defined period of time. So the person's question there was about serving notice and then whether 3 months catches. That's an unlimited term contract where you terminate with notice, which the vast majority of companies enter into nowadays. So if it's an unlimited term contract, you serve the notice period. As things stand, and based on Ministerial Resolution 279, that 3 month period, that notice period is going to be fine. And if you can demonstrate that you needed to make the redundancy, I think the courts are very unlikely to award arbitrary dismissal. And that's what that point is getting to, the 3 months compensation for arbitrary dismissal, which was much more common for courts to award pre-COVID in a redundancy situation. So, but certainly not an automatic obligation to pay that for unlimited term contracts. Employees tend to claim compensation for arbitrary dismissal over redundancy.
Yeah, which is along the same point, the same lines really. Employees can claim that, of course they can, but the question is, will the courts award it? And based on Article 279, Ministerial Resolution 279, Article 3, I think the courts are going to be much more likely to not award it, to say it was a dismissal under Article 279 and therefore was lawful because it was COVID-19 related. So we're not going to award the 3 months compensation. However, the point around having to provide housing allowance and medical insurance, that's a much bigger risk for companies. If they don't provide that, I can see the courts awarding those sorts of amounts to employees.
Is there a maximum period that an employee can legally be sent to unpaid leave? Is there a cap on how long it can be sent?
No, there's no cap. There's no cap on a period of unpaid leave. So, you know, some companies are saying, what we're seeing most common is any measures that companies are doing, whether it's a pay reduction or unpaid leave, they're saying it's between 2 and 4 months. And of course, it's going to be under review. Nobody knows where the world will be in 2 months, but it's between 2 and 4 months. So that's the sort of periods that we're seeing in the market, but there's no cap on how long that could be for.
Mm-hmm. Another interesting question coming from the attendees. Are you still able to terminate employees due to on poor performance as normal and without these normal conditions?
Yes, it is possible to terminate by reason of poor performance or gross misconduct, as you would in normal circumstances. What's interesting is that when ministerial resolution talks about the measures, it talks about where companies dismiss expats because of the measures that are in place for COVID-19. Now, if you're dismissing somebody for poor performance, arguably you might say, well, I'm not dismissing them because of the measures that are in place. It's entirely independent from that. Does that mean that I still have to provide accommodation allowance, other benefits? Technically, you might say no, because you fall outside of that definition, so you don't need to provide that. However, there is a humanitarian point here, which is part of the objective of this legislation, which is that if you're dismissing an expat national in this climate, well, for whatever reason, it's unlikely they'll be able to get another job. If you can't repatriate them, what are they going to do? You know, how will they afford to live here? Where will they live? How will they survive? And I think because of that, part of the objective of the legislation is to make sure that somebody's responsible for those individuals, and that somebody is their previous employer. So what I would say is, if you're going through a poor performance dismissal or gross misconduct dismissal, by all means, do not commit to paying allowances post-termination. Don't commit to that in writing, but just be aware that if they don't get another job and you can't repatriate them, then there is a risk that the authorities might say, okay, we understand that technically
Luke, you've frozen. I don't know if the connection is going to come back. To the attendees, they can still hear me well, and is it my connection problem? Appears that I'm fine on my end. Is Luke still working well, or he's frozen? Yeah, Luke has frozen. To the IT team, my IT team, can they come in? I think you guys can come into the chat and see if we can do something with Luke. But up until now, I think we've been covering quite a lot. I think we went over 90%. Oh, there's Luke back. I think we lost you for a minute.
Yeah, sorry about that.
No
yeah, but yeah, I mean, where we got to was that around the poor performance dismissals, and the point was that you could, yeah, if you're dealing with a poor performance dismissal, don't commit to anything in writing, but just be aware that if you do get to that point where you're terminating and they require that support, that they may, the authorities may expect you to provide it.
Right. One part of the law that I think it was a bit unclear, and it wasn't very clear on how to go forward. And there's a good question here. Can an employee be asked to go on an unpaid leave while he has accrued paid leave still on the balance?
Yeah, so this is the question, and this has come up as well, because one reading of Ministerial Resolution 279 is that the measures that are set out there should be gradual. And so the first measure of working from home is the first measure, and then the second one is paid leave, and then the third one is unpaid leave. And so the question is, do we need to exhaust the paid leave before we go to unpaid leave? And the answer to that actually is no, we don't need to do that. It all comes down to agreement with the employees. And whether you've exhausted the paid leave or not, you need the agreement of the employees in order to, you know, lawfully put somebody onto that period of unpaid leave. So I would say, no, we don't need to have exhausted it. It's just important that you focus on getting the consent.
Right. Somebody's asking here, and it's true, this is a bit unclear too. Can you please provide some more clarity on how the virtual market works? How much do we know about the virtual market? What is happening over there? Is this really working?
Honestly, I can't give you much more information because it hasn't worked in practice. You know, we haven't seen the full cycle in practice yet. It's still too early. All I know is that HR departments, PRO organisations, you know, corporate support companies may be able to assist and can register an employee's details onto the online system, and then the next stage of the process will be when companies need to recruit. They can look on the system, they can set out particular criteria that they want. It will hopefully bring up a group of expat nationals that they can then, you know, contact to interview. That's the way it's intended to work in practice. As I say, it's too early for us to see that working in practice at the moment. But I think the first step really is if you're being subject to redundancy, or if you are making somebody redundant, to just make sure you get them registered onto the website.
Right. Good. Let me see. There was one interesting one too, saying if somebody's put an unpaid leave, this is from an employee side of the equation. Can this person go into part-time jobs, and would this affect the relationship that is left with the previous employer? On
unpaid leave, Lorenzo?
Yeah.
Yeah, my understanding is that that is possible. If somebody's being put on unpaid leave, it is possible to agree that they can then go and do some part-time temporary work for another organisation and remain on the visa of their first employer. So yeah, I think that's possible. Obviously, you need to inform your company that that's what you wish to do and that's what you will be doing, and the company should agree to that. But yeah, as far as I'm aware, that is possible in practice.
We have a few cases of people that are still on probation period. What does the law say about how handling people that are still in probation period? And the question says, how do we deal with people on probation period, employees who have put on unpaid leaves?
Yeah, so there's a couple of points here. One is the length of the probationary period. So can we extend the probationary period because somebody didn't work for us for 3 months during it? The answer to that at the moment is no. The labour law is very clear that the maximum length of a probationary period is 6 months. And that's 6 months from the start date, whether they're on annual leave, paid leave, unpaid leave, whatever it is. So we can't extend the probationary period. So that remains a 6 month period from the start date. The second question is, I guess, you know, what if we want to dismiss them because we just can't see them, you know, us having the capacity to confirm their position with us long term. So Article 120 still sets out that it's possible to terminate somebody without notice while they're on the probationary period. Of course, that's subject to what it says in the employment contract as well. But that's the legal position. You can terminate without notice. And then I guess the final question then is, well, if we do that, do we have to keep providing allowances and benefits? Well, if you've terminated them in this period because of a lack of capacity, because of the economic situation, then it is still a COVID-19 related dismissal, and therefore the obligation to provide allowances does still apply.
Right. Okay, look, well, we're getting to the end of it. It's 11:50 almost. We still have 134 attendees. It's been a very good attendee group so far. We've been receiving lots of questions. There's still quite a few on the pipeline. We're going to take note of all of these. We have all your details, so we're going to come back to you with answers to all of this. The general message is that if you need support and advice on any of the templated, standardized, let's say, ready to go labor contracts, or if you need help in subscribing any of these at the Ministry of Labor, we can help you as Creative Zone. This is the work that we can help you with. And if you need help in making changes, making amendments to the contracts, dealing with disputes, dispute resolutions, this is where Look can come in, can help and advise clients, and so many other areas. So we're opening this up that we welcome our clients to get in touch with you, Look, for any considerations that they may need, any questions. As I said, this is sort of how we're kind of dividing things that we can help you with, we're happy to support, and things that relate to changes of the contracts, disputes, Luke can help with. Any thoughts on that, Luke?
Perfect. No, that's perfect, Lorenzo. And I can see that there's so many questions that have been asked that we haven't managed to get to. Sorry about that. But do feel free to contact me. I'm sure my contact details are on the invitation. And I'm more than happy to have a quick call or have a quick email exchange to help you with any of these questions that you have at the moment. But thank you, everybody, for subscribing. Amazing to see the numbers continue to increase as the session went on. That's always a good sign that the curve's going up for the number of subscribers rather than going down. And thank you, Lorenzo, as well. Thank you for asking all of those questions and facilitating it. It's been really good.
Not at all. We thank you, Luke, for your time. There was a lot of very good, valuable information for us and for our clients. Thank you for your time of today. And to our clients, thank you so much for attending. We're happy to continue being there for you and to help you go through this time. We ask you all to stay safe, stay at home, and hopefully this will be over soon, and we can go back to our normal lives and to have healthy and successful companies and businesses. Once again, Luke, thank you so much, and to our attendees, thank you for joining us.
Thank you then. Bye-bye.
Bye-bye. Bye to everybody.